there's several cases where the police will show up and they confiscate a ton of the equipment at the business. They'll come into your personal residence, search it for cash, see if you have anything on hand. They basically take everything. And if you try to transfer something because you find an account that they weren't aware of, if they find out about it, it's horrible because they'll go into court and say, listen, this is the reason why we asked for a restraining order, and they immediately did this.
Hey guys, there's a certain way to set up your asset protection plans that could help you in this scenario. God forbid it ever happened, but you might be in a situation where you wouldn't be completely broke and you'd still have some access to capital to live. The worst way you can ever wake up in the morning is to know that you lost everything while you were sleeping. What do I mean? All right. Ladies and gentlemen, not to be dramatic, but there's a thing called a TRO. I don't even know what it stands for. Is that temporary restraining order? Is that what it is?
Yep, it is.
Look at that. And the ABA won't give me my law degree. Guys, I figure this shit out on the fly nowadays. Come on. All right, TRO, it's when they freeze your assets. Okay, thank the heavens that did not happen to me. And I got what is called a CID. As of today, right, we're going to try to not to name names, but there is a case. It's in our industry of internet marketing. Now, there's been some buzz on TikTok about how I or Greg or, the FTC doesn't really actually go after people. The chances are so small, they're fear-mongering. And yet I'm seeing them accelerate. And then people are like, Chevron case, this case, that case. Greg and I have both on the record said on this podcast that, guys, when the FTC loses, and I use air quotes, loses some case, or they don't just retreat. They usually come out more aggressive, and they're a group of very smart lawyers, so they figure out little tangents and rounds. I feel, and we'll see if Greg agrees, I feel like they've actually picked up their pace a little bit the last few weeks, the last few months. And I'm seeing the letters TRO more than I have personally over the last few years. And just so you guys know, I'm not a lawyer, but I read these cases. Like every morning, I'm getting summarizations. I'm like really in this stuff. I don't know. I geek out on it now. And I'm just seeing TROs, asset freezes, lifetime bans, ban. I'm seeing these words way more than I was seeing them 2 years ago when I was like kind of in the heat of it. So today I want to talk about how asset freezes work, because I'm still a little confused. Do they have to warn you? Do they give you a warning once they freeze your assets? Are they frozen forever? We're going to talk about that in conjunction with a case that's going on right now that has had an asset freeze approved. And, there's a snippet of the sales call, and I asked Greg if he would read it out loud. Like, it's from the case, and it's not judgmental. We're not here to judge anybody, but this is an example of what can be said on a sales call that is going to get you banned or going to get you sued. Now, before you hear him read this, I'm going to tell you right now, by the time Greg is done reading it, all of you watching are going to say, oh, gosh, I would never say anything like that. That's atrocious. But then Greg can tell you how many of the sales calls he listens to. This is very typical. And so you don't realize it, but these are the kinds of things being said on the phone. And this, let's leave compliance aside. I'm just going to give my monologue right now. And of course, I'm coming out the other side. First of all, my sales calls never had stuff like what you're about to hear. They didn't. I'm telling you right now. But still, forget compliance. Don't we want to just be honest and ethical and truthful? And so one of the things I'm out there telling people is like, okay, you don't want to be compliant, that's fine. But if you're rejecting most of the laws and rules that require compliance, it means you're blatantly saying, I don't care about honesty, truth, and ethics. And so, yes, shots fired. That's up to you. Greg, what's up? How are you? Welcome back to the podcast. Thanks for being here as always.
I'm good.
As Greg and I were talking, by the way, shout out to, I don't know if I should say her name, initial B, first letter of her first name. She is pulling us over to TikTok, Greg. I think we're going to TikTok. There's a lot of conversation. Apparently, we created a bit of a controversy on TikTok, so it's time to take the truth and the message. There's a lot of bullshit being said around. All these gurus now are starting to do FTC compliance webinars and trainings, and it's all rubbish. Let me tell you something. If you're a guru and you're listening to this and you decide to do a training about the FTC and laws and rules, and you are off basis and wrong, you're just hurt yourself even more, because God forbid you do get sued, that shit's going to come up, and they're going to be very upset if you're out there actually training the wrong stuff. So with that said, Greg, do you want to read that quote because I think it's an example of kind of stuff that you're used to seeing on the phone.
Well, let me step back just a second on it and
Yep.
answer your initial question, because unlike other politicians who don't answer questions, I answer questions when I'm asked them. So the question you asked was, what is this TRO and what does that mean and how does
Yeah.
the government give it? When do you have to give notice and when you don't have to give notice? Okay. So a temporary restraining order. So a lot of cases, and there are several, like the Automators LLC case, the Gondolas case, or in the last year or so, several cases. There's where the FTC's come in and not only filed the lawsuit, but they filed a petition, a motion for temporary restraining order. And what that means is they can come in and they can take and seize all your assets. So you say wake up in the morning, and that's what you wake up to. Well, that's the concern you have. So a temporary restraining order is where they'll go and get it. Now, in some states, some federal courts, there is a notice provision. So the FTC can't just go and file it. They have to give notice to the other side before the court will grant that. It's not like that in every state. New Jersey will allow you to do it overnight. Florida will let you do it overnight. Utah will let you do it overnight. There's
What do you know
Nevada.
about Pennsylvania? I'm just curious. Do you know if Pennsylvania requires a warning or overnight can be done?
I don't know. I don't know. I have to look that up. But there are a lot of
Okay.
states that do. So depending on the jurisdiction you're in, first and foremost, some courts, you'll know the courts, they won't allow you to get a TRO without giving notice first and allow the other side to come to a hearing to argue the merits of the TRO. Other jurisdictions like Utah, Nevada, and Florida, New Jersey, they'll allow you to go in and get a TRO against a company ex parte. That's a Latin term that means by one party by themselves. Instead of
Mhm.
having both sides there, one party can go in there. So every state has a different rules that requires that. So if you're in a state that allows ex parte, they can file a complaint and a TRO the same day, freeze your assets, and then you have to scramble. And you have 10 days when a TRO is granted before they can have what they call an injunction hearing. It's either a preliminary injunction or a permanent injunction, which would mean that during the pendency of the action, the assets are frozen. And sometimes the courts are the FTC is successful in getting that, and sometimes they're not. Most of the time, they're successful. We'll just say that.
Okay.
So, a couple of reasons why you wouldn't get a TRO granted. Number one is if the FTC had started an investigation, like they did in your case, where they sent you a CID, and say that it blew up and they decided not to settle with you, and they went and filed a lawsuit and then asked for a TRO to restrain you with your assets, a very valid defense is, well, listen, we've been talking to the FTC now for 2 years. We've been meeting with them on a monthly basis. There's no reason to freeze our assets because the whole concept that we're going to just get up and leave and take all of our stuff hasn't happened in 2 years. So their rationale on trying to freeze assets this time doesn't exist, because normally the rationale that the FTC will argue in their motions for temporary restraining orders, you're just going to take the money and run.
Mm.
And if you've been in constant communication with them, they can't do that. So in the Nudge case, FTC versus Nudge, they tried to get a TRO. They had to give notice because of the communication. The court denied it because there was constant communication. So the fear of them getting up and leaving wasn't there. And so the FTC didn't get the restraining order against Nudge. Now, Zurich's, another real estate case in the state of Utah, same federal court, FTC was successful in getting that because they hadn't issued a CID to Zurich's and they didn't have constant communication. So the court said, "Hey, listen, we look at this and there could be justified reasonable basis of why we want to freeze assets." So the case that you mentioned that I'm going to read from, they've gone to court. They filed it 2 days ago on the 18th of September. They filed this case. They got a temporary restraining order. There's a hearing that was scheduled for today. I don't see anything that it's supposed to be moved. I just looked at the docket. One of the reasons why they argued for TRO in that case is telephone solicitations. And in there, this is the statement that you wanted me to read. So the sales reps on the phone says that their profit margin goals, remember we talked about goals in your
Of
case,
course. Yeah.
are 30 to 40% profit. Okay? And 50 to 80% profit. So that's what your goal should be. 30 to 40%, 50 to 80% profit, And when discussing if it would be possible to make around $60,000 a year, they said yes, it is definitely that would be feasible. We have 100+ people in the 100K club. That's over 10K a month that they're making. So that was a statement. So if again on this case that I'm looking at, number one cause of action, you go to why they raise this case, deceptive earnings claims. So false and unsubstantiated earnings claims. Number two, violations of the business opportunity rule. This is like the third case I've seen in a row where they're bringing this business opportunity rules where it's talking about sellers who are not registered under the act that offer for sale a business opportunity, which is to make money in a business, a new business the client's never been in before, a promise that they will or should make money, and provide them a plan of showing them how to do it. This is the fourth case I've seen the BizOp statute. Just this year, they've raised it. Now, why are they raising this? Because under AMG Capital Management, they're precluded from getting asset freezes unless they have something they can argue outside of 13B. So what are they arguing in this case? 19, for two reasons: telephone solicitations and the business opportunity rule. So you're going to see more and more cases bring up the business opportunity rules because more and more courts have been granting restraining order injunctions against companies based
And in my case, I know Section 19 is what we came down to, but business opportunity rule did not show up in my case, correct? And the biggest reason, everyone, just so you understand the difference, is in this particular case, business opportunity comes up because they are offering a done for you. They're offering a thing where they'll build you a business, get things up and running, and then they're saying you'll have sales within 30 days and all of that. Whereas in my case, I was purely an educator. So I'm offering you a course, I'm offering you training. Even if you bought our 10K, it was just a coaching program. And so there is that great distinction, and you do not want to fall under the business opportunity rule no matter what you do, because it's just that much more strict. So typically, like franchises and all of these, that's what they operate under the business opportunity rules, very specific. So basically, Greg, right now, if the FTC knows they've got you, you're strong, especially on telesales, they want to freeze your assets because they want to make sure you don't end up spending everything. They want to have money to be able to collect from you. And you've told me in the past that if your assets are frozen, it makes it a lot harder for you to fight and win the case because you're starting with, like, they've already got everything. So you have no hand to negotiate with, right? So can we walk through what it looks like? I want people watching right now to understand that, A, this is a reality. We're not trying to scare you, but this can happen, and it's happening right now to people I know. There's a couple of different people that are in this process. So you wake up, Greg. So if and in case you live in a state that doesn't require, that allows ex parte, so you wake up and what? Everything, your trading accounts, checking accounts, saving accounts, crypto accounts, you can't sell your real estate. They put a lock on any real estate you own. Is it just you? What about your trust? I've been hearing this a lot, Greg, lately. My trust protects me. They can't impact. What about the things that your trust owns? What if you have a bunch of cash accounts inside of a trust? Can they freeze those too?
So all good questions. Let me answer all of those. Mm-hmm. So what assets they go after? Pretty much everything. So the first thing they'll do is they'll find every bank account that you're a signer on. There was a case that I was aware of where it's actually a case FTC was involved in another regulatory entity. I actually got this case dismissed out of federal court, by the way. But they found that my client was a signatory on his mother's account because she had dementia, froze that account. So every single account that you have you're a co-signer on, or you're a signatory on. So banking, checking, 401ks, IRAs, defined benefit plans, annuities, brokerage accounts, all of that, they freeze. So then they look at real estate. So I had another case where Homeland Security had brought this case. They put a lien on, a Liz Pendant's lien on their home, so they couldn't sell their house. They'll sometimes put liens and garnishments on automobiles. They'll just come in and everything else. Or, the worst of it is when they get the SWAT teams to come. So there are several cases where the police will show up and they confiscate a ton of the equipment at the business. They'll come into your personal residence, search it for cash, see if you have anything on hand. They basically take everything. And if you try to transfer something because you find an account that they weren't aware of, if they find out about it, it's horrible because they'll go into court and say, listen, this is the reason why we asked for a restraining order. And they immediately did this. So I had a
Mm.
client that contacted me the day that they had an asset freeze. I didn't end up representing on the case because they didn't have any money because it was all frozen. That's what makes it so hard. You don't just lack the leverage because they have your money. You don't have any money to fight. So
Mm.
you're over a barrel from the beginning. It's they have
But
it's
isn't there?
an
I mean,
option.
everyone has a right to an attorney. So don't they? Do they not release any money? Like, what do people do in that situation? Then they just have
Sometimes
no legal representation.
yeah, so you petition the court to give like a living allowance, and I've seen that they've done that in several cases.
Okay.
Or if the court does agree to it, they'll give an allowance to hire an attorney. But it's not like that. I mean, unfortunately, they think it's like this civil criminal liability, and they all will argue in front of the court that you don't have the right to defend yourself because of your bad acts and fraud.
Mm.
So some courts are open to that argument. Some courts will not allow that argument. I personally think it's a violation of your due process rights if you don't have money to be able to fight and defend yourself. But there are several courts that disagree with that argument and have allowed that. That's why you see things like that Automators LLC case. Yeah, they settled for $22 million in February this year. Why? They didn't have any money. They didn't have a choice.
Yeah.
There's a lot of cases where they do that. And it's like they've settled because they don't have a choice. The FTC
Okay.
and CBER already has it.
So let's say I
You,
wake up this morning. Go
you,
ahead.
what you asked the second question though. What
Yeah.
about assets in a trust? Well, it depends on the nature of the trust. If you have it in a living trust, then the FTC will come and take that. If you have it in an asset protection trust, so there's one of the defendants in the Zurich's case. He had transferred his assets into an asset protection trust prior to years before the lawsuit. The FTC ended up suing this individual's dad, who was the successor trustee or the trustee of the trust, to try to pierce it. They ended up settling before they could figure that out, but the defendant, I talked to him just when we went to one of the events we spoke at recently. He was there, and I asked him about his asset protection trust, and he's like, "Save me on this." They were never able to pierce through it, and I was able to put assets in there. Now, they settled before that, so I don't know if eventually. So they were trying to get through it. They had sued the successor trustee, but I don't know. He was pretty affirmative that he felt like there was no way they were going to do it. And like I'm licensed in Nevada. That's where I clerked for the Nevada Supreme Court. They have like the most predominant asset protection trusts in the United States. They have shorter windows of period of time once the asset's in it that it gets fully vested and protected. So maybe I know that I had that case in Florida. The individuals were sued as affiliates. They didn't take his primary residence because they couldn't because of the homestead laws of Florida.
Mm.
So there's a lot of things in asset protection we look at for these type of cases as well, especially when it comes to TROs. Because if it wasn't in their name and they weren't a signer on the accounts, they wouldn't have been able to freeze the assets. So they would have
Interesting.
had access to money to be able to at least finance the litigation.
Yeah.
They're
So very, very important, guys. Just so you know, Greg and I are currently working on the expansion of NAOAC and our offerings into Greg's second major expertise, which is asset protection. So while he's working on my own stuff too, just generally, I mean, it's good to know, good to have. There's tax benefits and all of that. And also, I'm not just doing it to protect myself from the government, but like if God forbid I pass or whatever, I want to make sure my kids get the most of what it doesn't just go away to taxes and estate taxes and all of that. So we're going to be adding this. So you're going to soon be able to watch some really great training on this and actually work with Greg and his firm because they actually have a done for you service where they'll just come in and do it all for you. And you don't have to really, it's mind-numbing stuff to understand. I'm going to be honest with you. I don't like I love compliance. I will not be teaching estate planning. It
Well, I mean,
sounds
when we
horrific.
sat down in your case to the financial disclosures, we spent 3 weeks going over how to
Yeah.
structure, and
Yeah.
it worked, right? I mean, it
Yeah.
worked
Yeah.
because we
It works.
oh,
Yeah. It works. So,
because you came to me
um,
the first time, you were like, "Oh, I'm screwed," and I was like, "No, you're not."
yeah. Yeah. No, it does work. So Greg, so I wake up, and I don't want to keep saying I because I don't want to push this upon myself. Somebody wakes up and they've had their assets frozen. And at that moment, they basically cannot access any of their money. So my question to you is, they've got a mortgage to pay, they've got credit card bills, they need to buy food. What, and so I heard you say they can petition for a life allowance. Does that happen within the 10-day window? Like at 10 days when you as an attorney represent them back in court and say, hey, you try first to say, get rid of this damn asset freeze, and most of the time that's not going to work, and the judge is going to say, no, I won't. Then is it right there you say, well, dude, he needs some money to like live? How does that work? Like, how do you even like survive?
Well, let me just lay out the ground rules so you understand how it's stacked against you from the very beginning.
Mm,
Think about your case. They've been investigating you and looking at you for a year before they issue the CID.
mm,
In these cases, it's a good 2 to 3 years that they've been looking at the company before they file a lawsuit. So they get months and months and months to draft the restraining order motions, the complaint, and everything else. So when you get it, do you know what you get as an attorney? If I have to respond, I get 10 days. So then you have to decide, do I go into court unprepared and try to do it within 10 days, or do I ask for an extension? But in asking an extension, that allows them to keep your money for X number of days. So the
mm,
case I had in the state of Utah that we got dismissed out of federal court, I was in the UK. A second day on a trip taking my daughter who had just graduated from high school to England. I was sitting in a play. I was watching Les Mis on the West End. My phone's just blowing up. So in the intermission, I step out and it's all hell breaks loose. So
mm.
TRO, total asset freeze. So I step out of that and I spent the rest of the trip drafting motions to oppose that. We had to decide, do we go into court or do we extend? Well, I was out of the country. So we moved to extend, which sucked for the client because they had to have their assets frozen for a little bit longer, but prepared us enough that we went into court, we argued. We not only won against the TRO, we got the case dismissed, which was awesome, right?
Wow.
But
Yeah.
it doesn't happen all the time. They had a year to draft that. We had 20 days.
Mm,
Case that was just filed this week in Pennsylvania, they had 2 to 3 years to draft this. So not only did they frozen your assets, you got to try to borrow money to hire a law firm that has 10 to 20 days to oppose something that they've crafted for 2 to 3 years. It's
yeah.
it's so hard to be successful. I mentioned my success because it is unique. Like to get the case dismissed like that, that was unique, right? I mean,
Yeah.
they ended up filing in federal court or in state court, and then we fought it for 5 years, and there's a huge judgment against the client that just we're going to appeal. But it's just that there was no asset freeze, so we had our assets the whole time. Versus what you see in these cases, you're screwed. You're screwed. In my opinion, it's the closest thing as totalitarian society as you get. They
Yeah.
just not being able to defend yourself in a civil litigation, but the law allows it, and the courts allow it all the time. So you got to be
So
careful.
in some states, you said there's a requirement of notice. So let's flip over and talk about them, and then I have some follow-up questions. But one big key takeaway I had from this episode is, hey guys, there's a certain way to set up your asset protection plans that could help you in this scenario. God forbid it ever happened, but you might be in a situation where you wouldn't be completely broke and you'd still have some access to capital to live. So let's say I'm in a state that the person's in a state that they have to warn you. How does that look? So you wake up one morning and they say, we're taking you to court to get a total asset freeze, and how far away is that court date? And during that time, what can you or can you not do with your assets? What does it look like?
So what you try to do is you're asking specifically state by state for the asset protection.
No, no, no. No. I'm asking, what does it look like? Because you said there are some states that are ex parte. So you wake up in the morning, the FTC's already got the order. They're already your assets are frozen. And you said there are some states that require you to give notice. What does
Yeah,
that situation look like if you're in that state?
you asked you things like so in those states, what they do is they file the motion for temporary restraining order. They also file the complaint and they serve that on the defendant and tell them they have a date certain. So in the case we're talking about, it wasn't 10 days. They were given 2 days. They filed the case, they gave them notice yesterday. They were like, we have a hearing tomorrow. So they only had 24 hours in that case, which is
Mm,
a lot of time, but they did give notice, right?
mm,
So I think they actually froze assets. I haven't read the entire case yet, but
okay.
that's that's pretty quick. So normally in a notice state where they don't allow ex parte civil temporary restraining orders, you would give them notice and then you would have a hearing within 10 days.
Okay.
That's generally what you would have.
And during that period, it's not like you can take all your assets and
Oh.
move them. Like you are not to do anything with them.
Worst thing in the world you could do is start taking and just take the money and run because
What
it
about
proved.
what about if you need to pay an attorney? What if at that point can you
Oh,
wire a retainer to an
that's
attorney?
that's what you argue, right? You argue that hey, I did spend money, but it was just a necessity for this. It wasn't me taking money to go to Belize or South America or
Mm,
whatever. It was me to defend on this case. It was an ordinary and necessary expense to operate my business and to
got
protect
it.
my personal. So there is a good argument. But I had a client company that called me. They got a full asset freeze in Massachusetts, where I'm also licensed. I had been talking to this client. I had just started trying to do some work for them. And I was like, I had several concerns and I was trying to mention it to them and they got sued like within about a week of when they contacted me. Well, without talking to me, they got the TRO. So they froze their assets and the suit. They tried to send me a $500,000 on an account that they found wasn't frozen. When they told me that, I didn't ask for it, didn't know about it. Do you know what I did? I picked up the phone. I called the lead attorney for the FTC on that case, and I said, "Listen, I don't want this money. I didn't ask for this money. They're sending the money to me. If it hits my account, which I don't know if it will or not, I'm going to give it right to the commission because I don't because you just don't do that. And
Yeah.
so thank goodness it never hit my accounts, so it was never an issue. But you just never do that. I had another client, first thing TRO took out like 100 grand in cash. And I was like, you're gonna screw us on this defense. You better put that back in. This was the case in Utah in federal court, and they did. Thank goodness they listened to my advice, and we won against the TRO. But the state had made this huge issue about him taking the money out. So I stood up and said, "Well, Your Honor, what's the damage?" Client didn't really understand what it was because he's not an attorney. As soon as he consulted with me, put the money back, and it was there, and it's been there for the last 20, 30 days. So there is no harm on this. He didn't take the money and run; just didn't understand what the rules were. And the judge bought the argument, right? So just got to be mindful of all that stuff.
Yeah.
I mean, I had a third party in that case that I actually stepped up and represented. They weren't even a part of the lawsuit, but their accounts were frozen too, and they weren't going to. State was like, "We're not going to release this money. We don't care if they're somehow related. We froze their accounts." It's because one of the defendants was a co-signer on their account. So I went in there and was like, they couldn't make payroll, couldn't do anything like that. I was successful to get that TRO uh,
Wow.
lifted on that.
Yeah, that's right. You would not be able to pay your employees, pay benefits, life insurance, health insurance.
Biggest part,
So,
they couldn't pay for the fulfillment for the clients who bought the underlying service. So
yeah.
now they're like, we're really screwed because we can't go ahead and pay for people the coaches and the fulfillment piece. So people sign up for the service. So do you
Mm.
think the number of complaints goes down or up with that? Of course
Well,
they go, because
those people start suing you.
yeah, because as
Yeah.
soon as that happens, you have to let your whole staff work. We're closed, and if you don't have people picking up customer support calls or fulfillment calls or whatever that,
Yeah.
your business is dead. And you think the FTC cares about that? No, they think you've already
Yeah.
harmed them. So there was a case on this. This was the Online Training Academy case. It was out of California. And that's what happened. They were trying to get the temporary restraining order against them, and they opposed that temporary restraining order. They had like 500 clients that came up and said, "We want to use the service. We like the service. Don't take this away from us." And the FTC's like, "We don't care about that. We just want the money." And so they were
Wow.
successful in overcoming that case, and that case eventually got settled. There was a TRO. It got lightened. I mean, look at the Raging Bull case. They originally got a TRO on that, but the court in Maryland lifted that too for the same reasons. Like, we've got clients we got to take care of, and they're happy with the service.
Yeah.
So sometimes that argument works, but not in all cases. There's a lot of
What is
cases.
a what kind of allowances do you usually see? So let's say there's a full asset freeze and the court says we won't lift it. But then you go in and you're like, the dude's got to like live. He's got 2 children. He's got to be able to pay for food and roof over their head. What is the average amount that you usually see a court give them to live on?
Between $5,000 to $10,000 a month.
Okay. Someone once told me it's like only $2,000 a month, and that's why I'm asking, because I was like, how is that even possible? Like $2,000 a month's like not even going to cover rent.
No,
But
no, they'll do an average because think about it. With mortgage rates and everything else right now, I mean,
yeah,
the average mortgage could be $5,000 a month.
yeah, yeah.
So if your house goes
So
into foreclosure during the pendency of the action, it's not going to help the FTC. And they generally, I'll tell you about the FTC. In most cases, they don't go after your primary home. They'll go after your secondary homes or other things, but they don't go after your primary home. So
well, but you got to pay the mortgage on it, right? Like
that's
they may not go after, but the bank will go after it just
that's why
fine. So
they don't object to that as strenuously as they do in their case. It depends on the
yeah,
case, right?
yeah.
But they
Well,
normally will give you allowance enough to be able to maintain your house and make sure your kids are fed. But
good. So one of the big takeaways, and I'm going to ask anyone who's still watching this episode to give us a comment in comments below if you're on YouTube, is what is your take on wanting to learn more about the asset protection side? Do you want us to host a 2-3 day event, a virtual summit, and get Greg doing more work on it? I'll give you the TLDR on it. He'll teach you what can be done, what is to be done. You can't do it on your own. It's a bunch of legal stuff. Like I really don't think you can. So eventually there is a pitch, and the pitch is like, let Greg's firm do it for you. And I can't recommend it enough, but at the same time, we're curious, right? If we're going to do this, there's going to take a lot more of Greg's time and his staff's time. So give us some interest. Let us know if that's something you're interested in. I can tell you that it is one of my regrets. I think I could have done a much better job. I did an okay job, as Greg said. It ended up not being as bad as maybe I had feared as far as what I ended up having to pay. And again, thank you to the commission for not doing a TRO on me. I actually feel really blessed that was never even a conversation nor a threat made. I mean, they were actually really cordial and professional. And
10% calls, you weren't saying stuff like this. I
yeah,
mean, it was a different, and most of your sales were non-telesales related. You weren't
yeah,
offering it done for you service. There's a lot of reasons why it would have been difficult to have a TR in your.
got it. So basically, let us know. And I will say that that's the one thing that I had kind of tippy-toed around for a long time, and I never had put it fully in place. And I feel like if I had a good asset protection plan put in place before the investigation had begun, I think it could have helped. I think it could have helped a lot. So, having said that, everybody, thanks for joining us today. Leave us a comment below. Get the book. Come on. We're starting to do we are selling 40, 50 of these bad boys a day now. We got the Compliant Academy. The URLs are below. We got Complyly, which is taking off. The freemium is up now. 5,000 words scanned for free. You can get your score. Again, I continue to say I'm going to put Shardae's picture and her testimonial right on the main site. That's Greg's right hand at Guardian Law, and she loves Complyly, and so do many other companies that are using it right now. So go check it out. You can try it now. You can actually test it for free. So you got don'tsaythat.com for the book. You've got compliantacademy.com if you want to go ahead and grab time with Greg, with myself, certification, coursework. If you want to learn how to actually market compliantly, and you're like, hey, enough of telling me what not to do, tell me what to do, go to compliantacademy.com. And last but not least, by any means, probably the most important is Greg's firm has created 33 different templates of disclosures, disclaimers, contracts, terms, privacy policies, all these things that you need to have to help reduce your risk. You get them, you get rights to using them if you're inside of Compliant Academy, which you can start for just $297. It's basically 5 payments of $297. That's it. So this is all like our beta. We're out in the open party pricing. This is all going to go up. Okay. The book, $7 to get the digital version, and leave a comment below if you're interested in the asset protection stuff. All right. So go make it happen. Support the cause. The compliance revolution continues. If you want to be a giant, go compliant. Greg, as always, thank you for giving us so much of your time and for helping us start this revolution. And to all of you, I say, when life pushes you, stand straight, smile, push it the heck back. We'll see you on the next episode. Bye.